Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. No one anticipated the XRP coin, which debuted in 2012 to spawn one of the most famous legal fights in blockchain history, the SEC versus Ripple litigation. Ripple was already one of the biggest digital assets in the crypto industry long before Ethereum was even a glimmer in Vitalik's eyes. For years, the SEC's UV's Ripple case has dominated cryptocurrency headlines. Crypto fans have become desensitized to the fight over time. The result of the SEC's lawsuit will affect not just XRP, but also BITC, ETH, and the whole crypto ecosystem. Why is the U.S. Securities and Exchange Commission investigating Ripple Labs? What are the prospects for XRP holders at the Supreme Court? And what can we expect after the dust settles? Ripple, like Bitcoin, is a decentralized digital payment technology. Ripple was founded in 2012 with the goal of providing a quick and economical means to transfer multiple fiat currencies across borders. XRP is the Ripple network's native coin and is used to pay transaction fees. Ripple was first marketed as an appealing choice for banks and financial organizations wishing to shift cash worldwide without being mired down by cumbersome remittance difficulties. Officially, the XRP lawsuit refers to a SEC action filed against Ripple Labs and two of its officials, CEO Brad Garlinghouse and co-founder Chris Larsen. The lawsuit is overseen by Judge Annalisa Torres of the District Court of New York. So what are the accusations that the SEC and its unshakable chairman, Gary Gensler, are leveling against Ripple? Thousands of individuals sell and trade crypto tokens on secondary markets every day. So why should XRP face the full power of the SEC's jurisdiction? The greatest regulatory issue in the crypto sector began in 2020. When the SEC accused Ripple Labs of successfully generating over $1 billion via the sale of XRP coins. If you've been following cryptocurrency for more than a week, you're definitely aware that initial coin offerings, ICOs, like these are rather frequent in the market. The SEC is concerned that Ripple Labs and its executives engaged in unregistered securities offerings by selling XRP tokens to investors. The SEC believes XRP to be a security rather than a currency, and hence subject to securities rules. The SEC also argues that the Ripple CEO and co-founder were dishonest about the deal. They claim that Garlinghouse and Larsen made misleading and outright false claims concerning the XRP coin and failed to properly register the transaction, resulting in a violation of federal securities law. The Supreme Court created a procedure for determining whether or not an asset is characterized as a security in 1946. The Howey test requires that a security fulfill the following criteria. According to Ripple Labs, the XRP cryptocurrency is not a security. Ripple opposes the claims leveled against them since XRP is a currency and hence not subject to securities regulation. Ripple maintains that the whole court action is the result of the SEC's mischaracterizing the XRP coin and that the ICO was not an unregistered security sale. To stifle a creative and developing business, Ripple says that the SEC is inconsistent in its regulation of Bitcoin. Stuart Alderodi, Ripple's chief legal officer, has said that Gary Gensler needs to stop making decisions about how cryptocurrencies should be categorized in the future. Today, the lawyer said that it was likely that Gensler would make biased decisions in the future. He did this by bringing up a recent interview in which the head of the U.S. Securities and Exchange Commission said that every crypto asset except Bitcoin was a security. Chair Gensler has said again that all cryptocurrencies except for Bitcoin are unregistered securities. Since he already knows how the case will turn out, he can't vote on any enforcement case that involves that issue, tweeted Stutter. Gensler said in a wide-ranging interview with New York Magazine on February 23 about the cryptocurrency market that all other cryptocurrencies were securities because there's a group in the middle and the public is expecting profits based on that group, which he said was not the case with Bitcoin. So his words were taken to mean that all crypto assets except for Bitcoin fell under the SEC's jurisdiction, which got a lot of backlash from the crypto community. Jake Chervinsky, a lawyer and policy lead at the Blockchain Association, said in a tweet that Gensler may have already decided that every digital asset other than Bitcoin is a security, and that until the SEC proves its case in court, it doesn't have the right to regulate all cryptocurrencies. The lawyer also said that Gensler's opinion is not the law. Even though the commissioner said he was in charge of the cryptocurrency business, the lawsuit against Ripple, which has been going on for years, is getting closer to a conclusion. But the community is still waiting for the court to decide whether or not Sharp is a security. Even though we don't know what will happen with the case as a whole, we can look at what has happened in similar cases to get an idea of what could happen. In March 2021, the SEC sued Elbri, a blockchain-based sharing platform, for selling its LBC tokens without first registering them with the agency. But a court of appeals judge just decided that LBC tokens are only securities when they are sold during the primary sale. Many people think that Ripple is likely to get a good ruling if it can prove to the court, like Elbri did, that it never held an icon. If Ripple wins, XRP could be put back on exchanges like Coinbase and Binance. This would make the coin's price go up by a lot. The general counsel for Ripple, Stuart Alderoty, has said that the blockchain firm would immediately appeal its lawsuit against the SEC if Judge Annalisa Torres decides in favor of the regulator in the summary judgment proceeding. This information was provided by Alderoty in an interview that took place yesterday with Blockworks. According to the general counsel for Ripple, there are 3 different ways the Ripple v. SEC litigation might turn out. Ripple's outspoken general counsel believes that Judge Torres may rule in the company's favor when it comes to the summary judgment. Second, he stated that the judge has the ability to determine that there are contested facts, which will be addressed over the course of the trial. Alderoty said in his third point that Judge Torres may decide to issue the Securities and Exchange Commission a summary judgment in their favor. Ripple's general counsel has said that the Silicon Valley technology firm would not accept a victory for the SEC if this scenario plays out, as they want to promptly challenge the case before the U.S. Courts of Appeal. According to Alderoty, Ripple is prepared to take the issue all the way up to the Supreme Court in the event that the Court of Appeals rules against the blockchain corporation. He bolstered the spirits of members of the XRP community by saying that Ripple would win the lawsuit if it went all the way to the Supreme Court. According to Alderoty, the United States Supreme Court will find in favor of Ripple due to its protection against the establishment of an administrative state. According to Alderoty, I would be very convinced that this is a victory at the Supreme Court, not so much because of crypto problems, but because of the guarding against developing an administrative state. In addition, the general counsel for Ripple has indicated that the much-anticipated summary judgment might take place before the end of this month. As a result of the regulatory ambiguity, Alderoty recommends that new cryptocurrency ventures do not start in the United States. According to Alderoty, these brand new cryptocurrency ventures ought to be launched in a territory that has well-defined regulations governing the business. According to him, new cryptocurrency enterprises should travel to a jurisdiction where the regulations are clear, not light touch, but explicit. As a result of this animosity, some crypto firms are weighing their options about their future in the United States. According to a story from the previous month, Ripple exec David Schwartz made a veiled suggestion that the business would depart the United States if it is forced to do so. In a recent interview with Bloomberg, Ripple's CEO, Brad Garlinghouse, lent his support to Schwartz's statement by agreeing with it. According to Garlinghouse, cryptocurrency firms are already departing the United States as a result of the country's failure to get its act together. He went on to say that crypto enterprises based in the United States but operating abroad are not appropriate for the creativity of the nation.